Throughout our 5-part series, we've explored questions about who has access to justice and what creates environmental injustice, and what international laws exist recognizing Indigenous peoples' rights to conservation. Today, we're going to take a moment to better understand Indigenous rights, including inherent rights, Aboriginal rights and treaty rights, and whether we're non-Indigenous allies or Indigenous community members, we're going to look at the power they hold for protecting rights, lands, and water.
There's many involved. The friends and land are a small part of a huge picture. There's many allies that are standing up to help each other. Like we're all working to the same goal, whether it's chiefing councils, whether it's lands and resources departments in various organizations, whether they're NGOs, non-government organizations. There's land use planning, and there's breathing lands. There's Esquire inlands a bit there, and then there's the marine conservation. There's 30 by 30, meaning 30% of Canada has to be protected by 2030, by the year 2030.
Let's start with Section 35 of the Constitution Act. This is part of Canada's highest law, the Constitution. Section 35 recognizes and affirms the existing Aboriginal and Treaty rights of First Nations, Inuit, and Métis peoples. These rights are inherent. They come from Indigenous peoples' existence on this land long before Canada became a country. And they exist because Indigenous peoples are self-governing nations with their own laws and traditions.
As grassroots, we have rights. Like I said, we have inherent rights that was passed down to us. We have sovereignty rights. So sovereignty rights, we have our own constitution, our bundle. They call it the medicine wheel. Those are the reminders of who we are. We're supposed to share our medicine wheel. We are kind people. We are honest people to have that strength. That's that medicine wheel. So as grassroots, we want to have a say. We want to keep our land, to practice our ceremonies, to harvest what was given to us. So all those animals, all those four-legged, the waterfowl, all the fish, that's sharing. That's that knowledge that we have, traditional knowledge. We're going to know what's not working, that's affecting the water. We're going to know. We don't have to be scientists to say that, why is your fish floating? Why is your fish, dying? That's not science. That's something killing them. That's our traditional knowledge.
Section 35 means Aboriginal title and land rights are protected by law, and treaty rights, like rights to hunt and fish, gather and practice their culture and language, is also constitutionally protected and must be upheld. Section 35 matters because it affirms Indigenous peoples' rightful place as self-determining nations, and it provides a legal foundation to protect lands, culture, and their future. It is also a powerful tool that can be used to assert Indigenous rights and hold Crown governments like Canada to account. It also requires governments to consult and accommodate First Nations when actions could arise impacting their rights, lands, or resources. Now, Section 35 constitutional rights are meant to be a framework of mutual respect, protection, and recognition, but too often these obligations are not upheld. Instead of honoring rights, Indigenous peoples are forced into lengthy and very costly legal battles where grassroots actions are needed to protect what is already theirs.
We have rights that we have to remind our people. We have to tell them we've been oppressed for so long that we fight each other. And the government likes that. We fight each other.
Our people have a conflict in them. Because what's pushing forward to us since the turn of the century in the resource development, that we are trying to make the resource, the governments, mining companies, resource, whatever, logging, that we can't just give that up. It's conflicting. We're not in the market. We're trying to keep a harmony going for our future generations as well. You know, and it's important that rest of the world understands that you cannot keep digging up Mother Earth for $1, because you're digging up something that can't be replaced. And that is sad. We're not the ones digging the holes and leaving and moving on to dig another hole or chop down a whole bunch of trees. That's difficult. She said, hopefully our future can feel that harmony yet. Harmony that we came from the time immemorial since we got here as a people. My dad said, where are we going to move when they're trying to move us around? They already did that to us from our lands. They put us in a square box called a reserve. I said, we never gave up nothing. We still have it in us to live with harmony. And we're trying to make do with it, but it's going to be hard.
Section 35 rights are powerful, but in light of this frequent failure by the government to uphold them, a stronger, even more global response is demanded. And so in the 1980s, Indigenous leaders from across the world began working with the United Nations to create a declaration to protect Indigenous rights. After more than 2 decades of negotiation and advocacy, the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, was adopted by the UN General Assembly. It wasn't until 2010 that Canada finally endorsed the declaration, but only as aspirational, not legally binding. In 2014, Canada opposed the UN's efforts to treat UNDRIP as legally binding international customary law. And in 2016, after changes in government, Canada officially removed its objector status and fully endorsed UNDRIP without qualification. In 2021, we saw the passage of the United Nations Declaration Act, or UNDA, and that's the law that commits the federal government to aligning its laws with the 46 principles of UNDRIP. In 2022, Canada passed the UNDA Action Plan, and it outlines how it will implement UNDRIP into Canadian law. The UNDA, or UNDA, commits Canada to uphold commitments which include the affirmation of Indigenous peoples' right to self-determination for their lands, territories, cultures, and governance. It recognizes the collective rights of Indigenous people in international law, and it declares that Indigenous peoples have the right to make decisions about their own lands, resources, and development. And the courts have agreed. The Supreme Court of Canada has affirmed that through the UNDA, UNDRIP now forms part of Canada's domestic law, and recently, the federal court found UNDRIP is a framework for reconciliation that underscores the importance of Indigenous peoples' free, prior, and informed consent in all decisions affecting their lands and territory.
And I'm trying to encourage others to say, hey, wait a minute, what's going on here? Where's the information? Where's the documentation that, okay, you guys going to do something? Where's that information? How come we don't hear about it? How come we didn't know about it, till the last day or after, That's what I'm trying to avoid. I want people to know prior. These are ceremonial sites. This is a fishing spot, hunting spot to sustain livelihood. But we don't hear that. Nobody tells us, And good thing, like the Friends of Ottawapiskat River, they keep an eye eye out on the staking claims, the submissions that are coming up that are being asked to be put forward to the community. So as grassroots people, we do have a say. We put in our submissions. We say, hey, the junior company, we have a grave site here. We have a ceremonial site here. We have a fishing camp here. And this is our waterways. We travel. We want to know the process before, during mining, when they do mining. Because what's happening right now is we're not invited. We're not included.
We have to act accordingly to what we have here on Turtle Island, So we have all of us on that medicine wheel, and one day all of us are going to be here, and that we're all going to work together. We have to act accordingly to what the natural law and homeland laws are in both, you know what I mean? Like work together, like the Canadian and provincial law. We use those as well, and also we use the natural and homeland law as well. That's how it will be effective and efficient.
Knowing your rights is the first step in upholding them, and UNDRIP requires that governments must consult and cooperate in good faith to obtain Indigenous peoples' free, prior, and informed consent. Free means consent that's given without coercion, pressure, or manipulation. Prior means consent that is sought and secured before decisions or actions are taken. And informed means consent that is based on complete, accessible, and culturally relevant information. Consent means a decision that can be given, withheld, or withdrawn. And so when you put Section 35 constitutional rights together with UNDRIP, you have the tools for change. UNDRIP and the UNDA strengthen it, and FPIC gives it power to protect lands, waters, and future generations. As always, please like this video, subscribe to our channel, and check out the links in the description below to watch the other videos in this series and access the legal materials in our resource library.